Okay, so the Supreme Court overturned race-based affirmative action, and I've been making my way through the 237-page decision all day. It's kind of a mess. Clarence Thomas's concurring opinion reads like he started with the conclusions and then worked his way backwards. But there are three things in this decision document that stand out to me, things that I anticipate will get lost in the larger conversation. So in this video, I want to dig into those things and take you along for the journey. Let's go.
Affirmative action no longer constitutional, according to the Supreme Court justices.
They have rolled back 45 years of precedent.
What does this decision mean for the future of our universities in our area and what their racial and ethnic makeup will look like?
Let's start right here on page 1. You'll notice at the very top of the document is the name Students for Fair Admissions. This is an organization started by Edward Blum. He's a political strategist who has, for the last few decades, handpicked lawsuits to argue up to the Supreme Court that he thinks will help advance his conservative agenda. He's almost singularly responsible for what I think is the most anti-Black Supreme Court decision in recent American history, Shelby v. Holder, the gutting of the Voting Rights Act. Before this case, Blum tried to get affirmative action overturned with Fisher versus the University of Texas twice. In this case, his organization argued that this white woman missed out on admission because of affirmative action. But she was like an average student and she was white. Like, hey, no offense, but you got a lot going for you. Don't shoot the messenger. The case failed twice, and then Blum re-strategized, this time making Asian Americans the face of his repackaged effort to undermine race-based affirmative action. And it obviously worked. This decision bans colleges and universities from considering race in a long list of other considerations for admission. And that's really important here. There are many things an admissions professional could consider. Grades, test scores, extracurricular activities, the rigor of a student's high school curriculum, the region a student is from. And more frowned upon, they could consider things like whether or not your parents or grandparents went to the school. For example, if your mom or dad went to Harvard, you are 4 times more likely to get in, which is a huge boost. There are dozens of big and small things an admissions officer can consider, and race was just one of them. But not anymore. They can't consider race anymore, which is as arbitrary as it feels. And brings me to the second thing that stood out, Clarence Thomas's concurrence. Clarence Thomas argues in his concurring opinion that affirmative action, quote, stamps Blacks and Hispanics with a badge of inferiority. He even makes the argument that these programs admit people who don't deserve to be there, saying that the environment may be too competitive for them. Even though, again, an applicant's race is only one factor in the holistic admissions process. To be abundantly clear, a student whose race contributes positively to their holistic admissions profile is no more inferior than a student who's had a 4x advantage because of their literal genealogy. What Clarence Thomas is describing is an arbitrary opinion, precisely because other underrepresented demographics can still have their unique attributes count positively to their admissions consideration. I'll give you an example. Let's say there are 2 nearly identical young women applying to a STEM program at Harvard University. Same grades, same SAT scores, same extracurriculars. They're good. They're qualified and good. One woman is from Washington, D.C. Great. Let's go Caps. The other woman is from rural Appalachia. Let's say Blairsville, Georgia. An admissions officer at Harvard may say, hey, we have a lot of kids coming into our school from DC, but this young lady from Appalachia, she's qualified, she'd provide a perspective that is underrepresented on our campus. Taking a holistic approach, they look at the unique factors that make her application special, and they advance her to the next stage. That's affirmative action in college admissions. It's weighing and considering things. And one of the things that could be considered in that exact same way is race. But not anymore, because folks have been brainwashed into thinking that that process is unfair. But no, that process isn't unfair. That's how you put together a vibrant, diverse learning community. And the thing that blows my mind is that even with the unfair advantage of race-considerate affirmative action, the most selective schools are still extremely white. White people make up the largest demographic groups by a lot in the vast majority of Ivy League schools. To make matters worse, race-considerate affirmative action had already been prohibited in 9 states, and prohibiting the consideration of race in admissions resulted in a sharp decline in the enrollment of students from historically underrepresented groups. Which means that we know how this will play out. It's totally reasonable to expect that this decision from the Supreme Court will export that trend across the country. Why? Because the admission process is inherently competitive. Students are competing against tens of thousands of their peers, and any positive point of consideration helps, especially when some folks are getting a 4x boost because their pappy went to this school in 1953. The third and final thing that stood out to me was Justice Sonia Sotomayor's dissenting opinion. She said this: "The court subverts the constitutional guarantee of equal protection by further entrenching racial inequality in education, the very foundation of our democratic government and pluralistic society. Legacy admissions and the unequal distribution of resources for students across the country are a kind of inheritance that many Black and Latino people are simply excluded from. There was a time not too long ago when certain people of color were not even allowed to be on a college campus, let alone study there. And many of these groups are still underrepresented to this day. That's the fruit of the original race-conscious affirmative action we don't talk about enough." Justice Thomas and the other concurring justices insist that affirmative action violates the Equal Protection Clause. But where is the protection for Black and Latino students who inherited generations of unremedied social gerrymandering? It's why I disagree with this decision. Because to quote Justice Sotomayor in her dissent, the court's opinion is not grounded in law or fact. Okay, I'm gonna call it there. Sound off in the comments. There is so much more to be said about this, so I'll be paying close attention to your takes down there. If you like this video, it helps a lot for you to like this video. At Subtext, we're looking at things just beneath the surface. There's pretext, there's context, and then there's subtext. So if you're into that kind of thing, consider subscribing. As always, I'm extremely grateful that you're here, my friends. Peace.